Hello, welcome back to Business Law. This is Professor Crane. We are going to be discussing personal property. So previously we talked about real property, property law, real estate law. And when we're talking about real property, remember that is land and everything connected to the land. That's the definition of real property. And then personal property can be defined as everything else. Personal property, we can also talk about it discussing that personal property can be tangible or intangible, unlike real property, which is always going to be tangible. So what is tangible and intangible? Well, tangible personal property would be maybe a car, would be a paperclip, would be a book, your clothes, money in the bank, the actual physical cash dollars. What's intangible assets? That could be intangible personal property, could be a copyright that you possess, a patent, stock where you're not actually possessing the certificate, but it maybe is reflected upon like a bank account. It's not really physically there, but it's something you have. Maybe you could be talking about Bitcoin as was a crazy topic as personal property that might be seen as tangible or intangible. Both those things, tangible, intangible, would just be different classifications of personal property. What would maintain the overall persona of personal property? Some of the topics we're going to be talking about here is transferring personal property. We talked about that with real property as well, and statute of frauds. And remember, statute of frauds is just a fancy way to say, does this transfer need to be in writing? Do we need a contract in order for this to be a valid and binding agreement between the parties? Inheritance, how do we inherit personal property? We inherit differently than real property. Tax depreciation, again, is different. And then there are at least 5 ways a person can legally acquire personal property, which is important. So we're going to talk about possession, finding an item, gifts, accession, and confusion are all different means of becoming an owner of personal property. And what an ownership really means in legal terms for our textbook, for our class, legal ownership means the right to the word is escaping me, to expel. It's not expel, to exclude others from possessing the item. You have sole right of possession, and you have the right to exclude others from possession. That's what we're talking about, a legal ownership right. And possessing the item does not necessarily give you the right to exclude others from possessing the item, which we will be getting into momentarily. Now, here's a question here, and this is going to come up later on in regards to finding lost property, whether or not you can keep the property or how long you have to wait to have the property or that type of thing. So, and this is in the discussion of in regards to where property is found can be important. So in part of that discussion, where it's found, we got to talk about like the classification of that area. So here we have an area where we're talking about someone's backyard and a public park. They are adjacent to one another. How would you define those two things? Well, the person's yard, or just a regular, like my backyard, for instance, would be my own private property. And even though I might be adjacent to a park, once I walk onto the park, I no longer own the park. It's a public park. Then that becomes public property. And those classifications will be important later on. Perry has purchased a number of presents for his nephew, including toys, clothing, and shares of stock. What type of property are these? Well, we're looking through our options here. We're seeing that it's trying to differentiate between tangible and intangible property. And of course, clothing and toys, that's going to be tangible personal property, and shares of stock is going to be intangible property. You could potentially argue that the physical certificate itself might be some form of paper property, but that certificate, all it does is just mean that you are entitled to ownership of a company, which is actually intangible. It's an intangible thing, an intangible ownership. It's just defined by the certificate, so it would be intangible property. Hopefully I'm not confusing you on that concept at all. Just know that a stock is an intangible ownership, even though you might visualize a stock certificate. Quite often, if you're trading on E-Trade or something like that, you never get a piece of paper in regards to your ownership of the stock. You know, that's totally reflected in your account, etc. Marcel owns, this is a good tricky question here, Marcel owns a mobile trailer that he tows behind his car to various campsites so that he can go fishing and camping. Noah owns a similar trailer. He keeps on a wooded lot. Now, Noah has removed the wheels from the trailer, and the trailer is now permanently attached to an underground water well, electricity, and an underground septic system. Based upon these facts, what? This question here is asking us, what's personal property and what's real property? And if you remember the definition, real property is things that are attached to the land. That is real property. And things that are not attached to land, everything else is going to be personal property. So here we're going to see that the mobile trailer that is being towed behind the car going to various campsites, that's not permanently attached to the ground. That is going to maintain a personal property classification. But the other camper, even though it might be an identical brand and all that kind of thing, the wheels have been detached. It's physically permanently attached to the underground water well. Now, could you put the wheels back on and unattach and all those different things? Yeah, you could, and there's going to be a scopes of blurring there and some questions that you'd have to look into common law, how long would it take you to detach, all that kind of stuff. But for the purposes of our class, once something sounds permanently attached, and if a question says permanently attached, that means, yeah, that is real property now. It's attached to the land. It's real property. So Marcel's trailer, personal property. Noah's trailer, real property. That's a great question to understand the difference between personal and real property. The most common way to acquire property is what? Possession, purchase, accession, by gift. And this is kind of an interesting question to me. The answer here is by purchase. That's going to be the most common way. And I would love if this question maybe was a little bit more specific, like in the United States as an adult, what's the most common way to acquire property? Because as a child in the United States, you're probably acquiring most of your property by gift, right? Your parents are gifting to you all of these items, your macaroni and cheese, etc. It's kind of a continued gift. The child's not purchasing the macaroni and cheese, but now the adult, on the other hand, most common way to acquire property is by purchase. And we'll be talking about possession more later. It's an interesting subject. Here we go. So according to your book, possession is what? So possession is, let me go. Between persons, illegal persons. It is going to be, the correct answer here is going to be C. I've not looked at this material in 3 weeks. I'm actually 3 weeks ahead of the course right now, so I had to go back through the answers, but question C is the correct answer. So possession, what is interesting, you have two different the uses of the word possession, which can become confusing. So there's two different uses of the word possession. Possession can mean a common parlance, a common use of the word possession would be, this thing is in my hand, therefore I possess it. Now that is not going to be the legal term of possession in regards to actually you physically own it and can exclude others. So down here we see answer D is possession as 9/10 of the law. All right, so here's how possession works. If I'm walking along and I see a bicycle on the sidewalk and I pick it up and I jump on that bicycle and I'm like, woo, I'm the owner now, I possess it. Something's going to feel wrong, right? You're going to think, no, that's not how that works, right? And you'd be correct. That's not how that works. Physically holding a thing does not make you the owner of it almost all the time. I can't walk into Walmart and just start throwing stuff in my cart going, woo, I'm the owner of all this stuff. It's great. But now if I go home into my house and I run around my kitchen with a box and I just, throwing utensils out of my drawer and pots and pans into a box, I'm like, woo, I own all this stuff. I possess it. I would be, well, yeah, that's correct because I do. This is all my stuff. I own it, right? And so what's the difference there? Well, it's a legal difference in possession of how I acquired it, right? All the stuff in my house I likely purchased. The legal right was transferred to me by contract, essentially, right? I went to Walmart. I gave them my $50. They gave me a pressure cooker. Sounds good. Now I own that thing, right? It was a trade. Now I have the right to exclude others to the use of my pressure cooker. And so possession, there has to be some other bit that is giving you ownership, right? There's a gift, there's a contract, something occurred for you to acquire ownership, except for a couple special types of items. I'm going to talk about a couple just briefly right now. One type would be the abandoned item. if someone is just walking down the street with an umbrella and they're like, man, I'm tired of this umbrella, I really don't like the color yellow, and they just fling that umbrella on the ground with the intent to abandon it, and I'm walking up a couple hours later, I see a great yellow umbrella on the ground and I pick it up, I am now the new owner of that umbrella by possession. The previous owner abandoned it, and then I picked it up. Boom, possession actually gave me ownership. So that would be one time there, abandonment, and then potentially lost items, sometimes maybe even misplaced items. Potentially you could become a new owner of that item through various sets of circumstances we'll talk about later, but I just wanted to just briefly mention that up front. So here we go, possession. Possession confers ownership in a restricted classes of cases only when no other person was the owner at the time and the current owner took the object in possession. So that's the key there, right? Like abandonment. No one else owned it at the time. You picked it up. Another obvious category of possession is wild animals. If you're out hunting and you're hunting a deer and maybe there's a competing hunter coming along, it can be interesting as to who, if the deer is brought down, and I'm not a hunter, by the way, I forgive me if this example upsets you in any way, but it's a good example of technicality in the law and how ownership can be resolved, and essentially it's going to be the first person to lay their hands or get possession of grabbing whatever, that thing, and then they become the possessor, the owner of it, because it was wild. No one else owned it beforehand, similar to an abandoned good. All right. Regarding possession and ownership, all right, so here, quickly reading through these, it looks like B is going to be the correct answer. Possession conveys ownership only if there was no true owner at the time the current owner took the property into possession. No true owner, the wild animal, the abandoned good. During deer hunting season. I'm not going to go through this. And again, sometimes I flip through these questions quickly. Feel free to pause, read the question, figure out the answer, go into your text, etc. Listen back to what I was saying to try to figure out what the correct answer is. I'm going to just pass right on by that one. Lost or misplaced property. There is a distinction potentially between lost and misplaced property in the law. At common law, older law, there was always a distinction, and as law is advancing, sometimes it's changing, and this would be a law that would be flexible in states. Depending on which state you're in, the common law might be different, right? Those judicial made decisions might be different in each state. So this is just a generic overview, and it might be different in Ohio versus Kentucky, etc. But here we go. First, the owner is entitled to the return of the property unless he or she has intentionally abandoned it. I did copy this text out of the book there. I would use a more generic term myself, but that's how the text did it. First, the owner is entitled to the return of the property unless they have intentionally abandoned it. So we have the owner is entitled to return unless they intentionally abandon it, right? So if it's lost or misplaced, the owner is entitled to the right of return. The finder who knows the owner or has reasonable means of discovering the owner's identity commits some type of possible criminal act, likely a criminal act, and maybe some civil ramification if they don't return it. This rule applies only if the finder actually takes the object into their possession. All right, that's a little exception or little nuance there, right? If I'm walking along and I see the yellow umbrella on the ground and I opt not to pick it up, I'm not responsible for returning it to the owner that misplaced it or lost it. But as soon as I would take the umbrella into possession, well, now I have responsibility if I can find them a reasonable means of discovering them to do that. Lost or misplaced. All right. If we just went over that first part there. All right, so if you spot the wallet on the street, you have no obligation to pick it up. We were talking about that. If you do pick it up and see the owner's name in it, right, maybe their driver's license or something, you have a legal obligation to return it to the rightful owner. The finder who returns the object is not automatically entitled to a reward. So I cannot require the owner to give me $100 bribe or gift, or forcing them to give me money in order for me to give them their wallet. Now, on the other hand, if I mail them their wallet, or if I take my time potentially to drive the wallet to them or something like that, I can, sorry, I'm trying really hard not to do them there. You are entitled to reasonable reimbursement as a quasi bailee, as a nice person returning the item you are entitled to reasonable reimbursement of any costs incurred in returning the item. If the owner fails to claim the property within a time allowed by statute or common law, then they might be considered to have abandoned it. Then the property goes to the owner of the real estate on which it was found. Remember, there again, thinking about public property or private property can make a difference there, right? Leo, I'll come help you in a little bit. So the property goes to the owner, the real estate was found if the finder was a trespasser. So I have my backyard, I own my backyard, and if somehow some lost property gets on my backyard and a trespasser trespasses on my land, finds this random property, they would not be entitled to that random property. Kind of makes sense. They're a trespasser. Actually, I would be the one entitled to that property if the true owner of the property is unable to be found for that statutory period of time. Also, too, we see the goods can be found in a private place. Then you're, again, not able to acquire that property. And there's a question in regards to what is a private place, what constitutes a private place, such as is an aisle of a grocery store a private place? It's probably a public place. Again, it's going to depend. Instead, we have the back of the food room rack, like if there's some random property found in the back of a grocery store where it's employees only, well, of course, whose property is it? It's probably an employee's property, right? You should be able to find the true owner there, and that's one of the reasons why you can't transfer ownership if it's found in a private place. If the goods are buried, which is interesting, if you find buried goods, then you cannot become the true owner of those items. And also, if the goods are misplaced rather than lost, you cannot acquire ownership of that property, unless there would be some other rules. Remember, this is just a generic overview per our text, but this is interesting. It's a good place to start in learning about lost or misplaced property and when the finder can become the owners. I would call this entire paragraph here finders keepers. That's the question. If I'm the finder, may I be the keeper? And we're seeing the times where the finder cannot be the keeper. That would be items 1, 2, 3, 4. Finders keepers doesn't work. If it's not 1, 2, 3, 4, potentially finders keepers is going to work for you as long as you give that period of time required for the true owner to appear and find their property. Abner inadvertently dropped his expensive scarf in the aisle of, let's say, Target, and unknowingly left the store without his expensive scarf. Under common law, the scarf would be what? What do you think here? Lost, mislaid, abandoned, etc. This would be an example of lost. This is a lost item. Inadvertently dropped it. Abner had no idea. If Abner continues going to many other stores, Abner is going to have no idea where Abner dropped the scarf. It's lost. Brenda put her engraved pin on the department store counter after signing the Visa receipt. She intended to pick her nice engraved pin back up and put it in her purse, but she forgot to retrieve it. As she picked up all her packages, Brenda leaves the store without her pin. Under common law, the pin is, what do you think? Lost, mislaid, abandoned, etc. It's not abandoned, it's not lost, it's mislaid. She put it down, she knows right where she put it, but now she finds that it's out of her possession. She would know to go back to what spot to look for it. It's mislaid. I never mislay or lose anything, promise. Jules, the owner of a dry cleaning store, discovers that a customer has forgotten her expensive engraved pin on the counter. I love expensive engraved pins. Need more expensive engraved pin questions. From the name on the pin, Jules knows the pin belongs to a regular customer who will be returning for her dry cleaning clothes in about 1 week. Under common law, this is a mislaid item. If you scroll back to Finders Keepers rules, we'll see the exception. You can never become the new owner of a possessed, mislaid item. So under no circumstance, in regards to the rules we're following here for Finders Keepers, no, Jules can never, ever, ever have the pin. Kurt sees that someone has dropped their wallet in the gutter on the street. He would like to help the person out by returning the wallet to the true owner, but he's in a hurry and leaves the wallet where it is. Under common law, perfectly fine. You're under no obligation to pick that up. Dana was using her metal detector in a farmer's field, and she found an old tin can filled with a large roll of $100 bills. Dana is wondering whether she can keep the money. The rights of ownership regarding lost or mislaid property is what? And let's talk about where do we get this law from? I've mentioned common law, we've mentioned state law, we've mentioned statutory law a little bit. This is going to be state law, it's going to be common law, and potentially, right, the legislative branch of the state government can issue laws in regards to lost and mislaid property. They probably have for every single state, I'm guessing. And so it can be regulated by common law and statutory law. The legislative branch of the state can go ahead and issue some statutes, like in Ohio, would be Ohio Revised Code regarding mislaid or lost property, right? And also judicial decisions can affect that ORC or potential areas of the legislative branch has not issued a particular code on yet. Also, we're wondering, hey, that's one good question, but hey, can Dana keep this old tin can? Let's pretend it was buried. If buried was in here, that would be cool. It's not in the question, but let's pretend it was buried. Could she keep it? We scroll back up to Finders Keepers, you'll see, no, one of the exceptions is if it was buried, you can never claim ownership. You're just holding on to it for the true owner. Additionally, we don't really know whether or not Dana was allowed to be in this farmer's field, or if she owns, I should say, does she own the farmer's field? Is she a trespasser? That kind of stuff. Let's say it's Dana's property. Dana bought this field, and she has a metal detector and thought, hey, this would be a great time. Maybe she's looking for old Civil War pins or something like that, and she happens to find this bit of property. Well, she potentially, because she's the real estate owner, potentially, in the law of the state, she might be able to do it. But remember, it's buried, so as far as the text is concerned, likely not. What's up, buddy?
Can you change it to fast bros?
Dad is going to be finished up probably in 5-10 minutes, and then I'll switch it. You guys get some exercise. I'm almost done, buddy. Go. But if she's a trespasser, it's never going to go to her. And if it's buried, never going to go to her. Marian was riding his old bike. He crashed it. Some other bikers helped him out. He was injured. He decided he didn't really like that bike. That's probably why he crashed. It's not a safe bike. He decides he doesn't want it. He abandons the darn thing, right? It doesn't say in this list of questions abandons, but he clearly decides doesn't want the bike anymore. Someone else, Tony, comes along, wants to use the bike for parts, takes it home. Tony, going to be the new owner? And the answer is yeah, it was abandoned. So Tony's now the new owner by possession. Sam found a gold ring in Frodo's garden. If the true owner of the ring cannot be located or does not claim his property, the found property goes to the owner of the real estate, Frodo. Right? Sam, trespasser, finding the ring in Frodo's garden. If the ring was buried, owner. If Sam was a trespasser, only. If the ring was misplaced and not lost, only. If Sam was a trespasser, or the ring was buried, or the ring was misplaced and not lost. I'm going to allow you to go back through and make your best guess as to the answer there. It's getting recorded here for my class, buddy. Here, come on up. All right, gift. To make an effective gift, inter vivos, which means while you're alive, or causa mortis, which means you are dead, the law imposes 3 requirements. 1, the donor must deliver a deed or object to the donee. The donor must actually intend to make a gift, and the donee must accept. So we have delivery, intent, and acceptance. Acceptance is the 3 elements of a gift to prove that a gift actually happened and property was transferred and we've got a new owner. And we can see here that delivery and intent is on the donor side, so you'd be looking at facts related to the donor, and donee has to accept. You were looking for facts related to acceptance there. All right, delivery. Delivery typically is going to be thought about as control. You got to give control to the person that you're attempting to give the property to. Typically, that's going to be literally taking the property and handing it to them. Now, it can get a little bit dicier when you're giving them control through some other method. One example could be here from the book. You might have a gift for someone in a trunk. Let's say you lock the trunk. The trunk only has 1 key, and you don't give the person the gift of the trunk. You give them just the key, and maybe you still have this trunk in your own house. So there would be some questions in regards, well, did you really deliver it? Well, maybe you gave them control because you gave them the only key to open the box. But on the other hand, the other person still possesses the box, and you can just call a locksmith and they'll open it up for you, right? So anyways, that's a great gray area of the law. You're not going to get a question that technical in the exam, but it's something certainly to think about in the interest of what is delivery. But what we would like to see for delivery is you literally just give the thing to the other person. They get possession. And that's going to show you, and also intent. Well, let's go to intent right here. Let's just scroll up. The intent to make the gift must be At the present time, not later. That's important. Intention to give a future gift does not constitute intent. Why is that? Because you can change your mind. That's why typically maybe you bought someone a gift or you're thinking about giving them a gift, but then something happens, right? Maybe your life changes or you change of heart or decision, whatever. Until you give the gift, you don't have to give the gift. It's not literally transferred. You're allowed to keep the thing and not go through with the making of the gift. Now, there's going to be an exception in regards to causa mortis gifts upon death, but we'll get to that in a moment. Acceptance, not only do you need intent and delivering all these things, the person needs to accept the gift. Well, why is this important? Sometimes you really, really, really don't want the gift. And let's use the example of your house. Let's pretend you own a house, and the area of the house, let's use Cleveland as an example. This is something that happened in around the 2008 time period. It's still an issue for some properties where whole neighborhoods were going downhill because these 2-year ARMs and 5-year ARMs, these interest rates were going up. People could no longer afford their houses because of bad loans, and then people are having to abandon their houses because the banks are threatening to foreclose upon them. And so people feel that their house might get taken away, so they go ahead and they move out and they find somewhere else to live. And especially if this is happening over and over in the neighborhood, you're getting more and more worried about, the new neighbors, the houses are abandoned, all this kind of stuff. That's worrying. So you move out. You expect for the bank, let's just use the word Chase Bank, for instance. I can't recall if Chase Bank was one of the causers of this. That doesn't matter. I'm just using them as an example. I apologize if you work for Chase Bank or something like that. Think they're a fine institution. Anyways, let's use Chase Bank for example. Let's pretend Chase Bank holds the mortgage on the house. They have the right to repossess the house. The person has moved out of the house, but the neighborhood is in deterioration, and the house itself, let's say, is in deterioration. The neighborhood's going downhill. Maybe the roof needs helped out. Some raccoons have moved in, whatever. It's not looking good. Chase Bank comes and they value the house, and they realize that if they take over the house, that a number of things are going to happen. They're going to be the responsible owner at that point. And let's say the grass needs to be cut and the city's putting violations on there. And maybe the roof really needs repaired. And so then the city's putting violations on there too in regards to that. You need to keep your house up and you need to keep your lawn mowed, these different things. So there's all these fines building up on the house. Potentially back real estate taxes are owed. All of that is going to travel with the new owner of the house. Chase Bank kind of runs the numbers and says, man, if we repossess on this house, we're going to end up owing money. So therefore, we don't want to repossess this house. We don't want to become the new owners. So then the problem is the person that abandoned the property, they're still the owner, even though they would really not like to be, and they didn't expect to continue ownership. So the city is going to keep coming after them for real estate taxes and to mow the yard, and those fines and penalties are going to continue to follow them like a noose around their neck. So what would they really like to do? They would just want to give the house back to Chase Bank. Chase Bank, they call them up, say, hey, we'll give you the house. Chase Bank says, no thanks, we don't want it. So then what does the person do? They take the deed, they sign on it to Chase Bank, they sign their name, and they send Chase Bank a brand new deed as a gift. They have the intent to make a gift. They sign out the deed, they mail it to Chase Bank. So they're doing delivery and intent. Both of those things checked, right, as in regards to gift. But then the gift goes to Chase Bank. They open it up and they see that they're being given the gift of this property. Of course, Chase Bank has to accept the gift. Chase Bank can easily reject the gift, tear up the deed, throw it in the garbage, and not become the owner. But that's why acceptance can be interesting, right? You might assume that a person always wants to accept the gift. Nay, nay, not all the time do you want to accept a gift. Gifts causa mortis. Gifts causa mortis. When do you have a gift causa mortis? There's a subtle difference between saying, if I die, the watch is yours. That doesn't work for gift causa mortis. You have to say, this watch is yours unless I survive. Condition precedent, condition subsequent, blah, blah, blah. I'm not going to explain the difference of those. I'm just going to say, if you see a question that says, if I die, the watch is yours, that does not work for gift causa mortis. And if I say the watch is yours unless I survive, that is a gift causa mortis. If you'd like to know about conditions precedent, conditions subsequent, there are plenty of YouTube videos that are 15, 20 minutes long just on that subject. So I'm not going to really go into the legal significance of the difference. Just understand that there is a difference between those two things. And if you do that, you can then avoid some of the necessary elements of a gift, which typically is going to be delivery. You don't usually need to do delivery. You just need intent and acceptance, and then delivery will be check the box accounted for because of the gift causa mortis situation. And that's again because gifts typically can be taken away. But if you intended to make a gift, but then you passed away, and you intended all the way up to death, you never took it back, then upon your death, then the gift becomes sort of realized at that point in time. So it's about the only time that you can sort of have a gift where a gift in the future is going to be successful, because typically gifts need to be done at the present time. Holden wants to give a gift to his mentor. A gift, let you look through those and decide based off of our discussions there. Most gifts are made between living persons without conditions attached. Such a gift is known as, I said this real quick right in the beginning, causa mortis gift. That is a gift upon death. Inter vivos gift is a gift during the life. A gift requires what three things? Well, there's only one answer, but what are the three elements of a gift? Pick them out. Mark tells his son Nick that Nick can have Mark's car. Mark gives Nick a set of keys to the car, but keeps a set for his own use and keeps title in his own name. This gift is, what do you think? What do you think? What's going to be the issue here? Probably not acceptance. Certainly seems like Nick is accepting. He took the car. I assume Nick probably wants the car. Acceptance is probably fine. Well, we're thinking delivery. Delivery is probably a bit of the issue. What has Mark given up legal control? Title is still in his name. Title's still in his name. Mark can take the gift back anytime he wants. Aunt Vicky has a regular bank account under the names of Aunt Vicky and Linda, her niece. Every year on Linda's birthday, Aunt Vicky puts money in the account and tells Linda that she'll receive the money when Aunt Vicky turns 60 years old. Aunt Vicky turns 60 but never gives Linda the money. Based upon these facts, again, we see here Aunt Vicky's maintaining control. It's talking about a future gift. These things should be raising red flags. So you should be thinking about trying to find an answer revolving around either control or it being a future gift. Mary is afraid he will not survive the dangerous surgery he must undergo tomorrow. Mary gives Pippin his entire stash of fireworks and tells Pippin that they belong to Pippin unless Mary survives the surgery. A gift made in contemplation of death. Death is called what? Accession is something that is added to what one already possesses. In general, this is a way that you gain ownership where you can exclude others to ownership. This is another means, right? We talked about possession now as a means to sometimes get ownership. We've talked about gift giving as a means to sometimes get ownership. We've talked about purchasing, right? A contract as a means to gain ownership. Here's accession. And accession is going to be when something is added to it. So a good example here would be a cow that gives birth and has a calf. That would be accession. You own the cow, you own the calf. Another example would be when a person adds value to another person's property. A typical tricky question is going to be when someone steals something from you and adds value to it. Like my car gets stolen, but then someone adds a sweet new motor to my car, and then I get my car back. Well, I become the new owner of the souped up vehicle, and the person who added the engine to it because they stole the vehicle has no rights to the accessions, something they added on to the car. Confusion is another way to gain ownership of goods. Confusion happens where owners are commingling a bunch of properties together. A good example would be the grain silo. A bunch of farmers get together, they build an expensive grain silo together, and they all decide they're all going to put their grain in the silo. They're going to keep track of how much grain they put in. Then when they take their grain out of the silo, they're entitled to that much grain. Well, the thing is, it's all mixed up, so you're not exactly getting the grain maybe you put in. You're getting a mixture of all these different farmers' grains, and you become the owner of that. But that's all by agreement, by confusion. All right, I'm going to let you look at these and choose an answer. Based off of my quick discussion there and a reading of those paragraphs, you should be able to answer any of these questions. A fixture is an object that was once personal property, but that has become so affixed to land or structures that it's considered legally a part of real property. So this can be personal property transforms into real property. There's different ways this can happen. Annexation, adaptation, and intention. The three deaths to determine whether a particular object has become a fixture. Affixing it And what was the adapted use? Was it to enjoy the property and intention in regards to when you put it on the property, did you intend to make it a permanent part of the real estate? And why does all this matter? Well, think about it as a tenant. In college, I rented a place. Let's pretend I really didn't like a particular light fixture maybe in my bedroom. I really would like a fan up there with a light on it, but it's only a light. So I go to Lowe's, I buy myself a nice light fixture with a fan on it. I carefully take down the landlord's light fixture, I put it in the closet, I put up my own fan and light fixture, affixing it to the ceiling, so now I've got a nice fan in there for my own use and enjoyment, and I intend to not make it permanent. I intend to take it with me and put the landlords back up there. Wow. So what's the problem here? Well, the problem is it's now real property. It's not personal property. Who owns the building? Well, I'm the tenant. I don't own it, so my landlord now owns it. So I've just given my landlord the gift of the fan with the light. What's up, buddy?
I'm gonna turn some Mario talking to Princess Peach.
Mario talking to Princess Peach. All right.
I mean,
I don't remember where I was there, but I would like to take the fan with me. So in most circumstances under state law, what the typical result is going to be, because my intention was to take it back down and not make it permanent, and also it was for my use and enjoyment at the time, likely I'll be able to remove the fan and the light. I'll get to keep that, and I'll put the landlord's light back up, and it will remain the classification of personal property. So that's important. Tenants' fixtures. Tenants' fixtures can also, I'm giving the example of the typical regular person who rents a place to live in. Also, there can be fixtures that are trade fixtures, meaning you're a commercial business renting a location and adding things to it. Or you can be like an agricultural tenant. Maybe you're renting a barn and you're making additions to the barn, or that type of thing. All those different fixtures potentially can be removable when you leave. This is tenants' fixtures. Feel free to read through this. A couple of the key things here. When you're removing fixtures, they must be removable without causing substantial damage, and they must be removed before you turn over possession. So my example with the fan and the light, I need to not cause substantial damage by taking it back down and putting the landlord's light back up carefully. That makes sense. Also, I would need to do this before I turn over possession of the landlord. If I want to do it a couple days later, after I've moved out, going to be too late. All right, this is another difference between what's personal property and what's real property. Remember, once you're affixing something, it's going to get the classification of real property. So here we have the built-in cabinets, the built-in bookshelf, and the bolted to the wall. All those things are going to become real property because they're affixed to the property that's affixed to the land, right? As soon as you have a house affixed to the land, that's real property. You affix things to the house, that also becomes real property. The child's desk would be personal property, right? It's free floating in the room. You can move it around, personal property. All right, so here we have a person on a contract to sell their home. They want to keep something. What should they do? They should put a clause in the sales contract and make it known that they intend to take the item with them. That way there's not an issue when it's closing time and the buyer thought they were getting the chandelier or whatever fancy thing or whatever thing it is you wanted to take with you that's affixed to the house. You want to take something with you, just put it in the sales contract. Put it out there as part of the notice when someone's reading about the different qualities of the home or the real estate that's for sale. They'll know what is part of that bargain or not, because typically you would assume anything attached to the real property is coming with the house. Again, there's another great question there. We talked about classification of fixtures. Potentially fixtures can be agricultural fixtures for like a farming business, trade fixtures for any other type of business, and can be domestic fixtures for the typical tenant who's living in the apartment as their domicile. Another question I feel you should be able to answer and pick out the right answer there based off of our previous discussions. You can scroll up a couple pages there and you should be able to determine what type of fixture that is. Again, a question about categorizing fixtures. What type of fixture is it? Here we have a Sherilyn rents the apartment where she lives. So is that going to be domestic, public, or agricultural, or trade? Public is not the correct answer. Dad is a tenant on a large farm where she also lives and has an office. She has certain tenant fixtures that she's installed on the premises that she would like to take with her when the lease expires. In order to accomplish this, remember we were talking about the fan, how I'm carefully taking it down not to cause the damage, and I'm doing that before I move out, before the landlord retakes possession. So look for the correct answer there that has those types of qualities to them. No substantial harm and occurs before the trading of possession takes place, right? I move out as the tenant and the landlord regains possession. This was a long one. I apologize it was so long. These last couple ones, this was personal property. I'm going to go into intellectual property and then finally international law. They're all a little bit more lengthy, but I'm trying to get good information in here for you so that you're successful on the tests and quizzes. Thank you all for your hard work. This is Professor Crane signing out for Business Law. Have a good one.